I am Aaron Ford, and I'm your Attorney General, here today to talk about the leaked draft opinion penned by Justice Alito that overrules Roe v. Wade. Roe v. Wade has been the law of the land for 49 years. Because of Roe v. Wade, generations of women have been able to access safe, legal medical care and to make decisions about their bodies and their futures. We do not know if the draft opinion leaked yesterday will be the opinion that's actually issued by the Supreme Court. Chief Justice John Roberts has confirmed, however, that the document is authentic, but that he's also said that it does not represent a, quote, decision by the court, unquote. What we do know is what we've always known, and that is that the very existence of Roe v. Wade as precedent is at stake. The right to an abortion and a constitutional guarantee of privacy and bodily autonomy has been under sustained attack for decades. And this decision, if made public, if made official, will dismantle the nationwide guarantee to that right. These ongoing attacks are exactly why I have joined numerous amicus briefs protecting abortion rights. We cannot and will not stop fighting for this right. Our office joined an amicus brief in this very case, Dobbs v. Jackson's Women's Health Organization, regarding an abortion ban in Mississippi. If the Supreme Court does issue an opinion like the one that has been reported in the news, it means that Roe v. Wade is overturned and there is no federal constitutional right to an abortion. It means that states will have the ability to determine whether or how to regulate abortions under their own state laws. Here in Nevada, overturning Roe would not be felt immediately. Voters in Nevada guaranteed a right to a legal abortion until 24 weeks of pregnancy by referendum in 1990. This law, codified in NRS 442.250, cannot be changed or repealed in Nevada unless voters pass a referendum to change or repeal it. Let me be crystal clear to any Nevadan who is listening to this message. If you need reproductive health services, make that appointment with your doctor. We will protect your right to make decisions with your doctor about what is best for your health, your family, and your future. This, however, does not mean that we should not be concerned. Indeed, there are those who would say that any focus on access to abortion here in Nevada, if Roe v. Wade is overturned, is nothing but gaslighting. But they're simply trying to lull other Nevadans into complacency. For example, a federal ban on abortion could supersede our law, or a future governor's administration or a state legislature hostile to abortion rights could work to find ways to restrict access within the framework that has been approved in the referendum. There are, in fact, some congresspersons and senators to this day working to pass a national law affecting the right to abortion. We'd be naive to believe that certain folks here in Nevada aren't likewise looking for ways to undermine the right, our laws notwithstanding. So again, let's not be complacent. In fact, instead, we have to be on guard against any attempt to make Nevada's right to an abortion a right only on paper, and we have to fight back efforts to restrict meaningful access to abortion. Now, some states are following in our footsteps to codify abortion rights into law. California Governor Gavin Newsom has announced that he will push for a constitutional amendment guaranteeing abortion rights. In other states, things look a little different. Millions of women could lose their rights. Some states could entirely ban abortions in any and all circumstances. That means there would be no constitutional right to an abortion in those states, even before viability. No right to an abortion in a case of rape. No right to an abortion if a woman's life is at risk. And no right to an abortion if there is a fetal death in the womb. In Missouri earlier this year, a bill was proposed that would have banned abortions in the case of ectopic pregnancies. To be clear, ectopic pregnancies are never viable and often fatal for the patient. Though that language was removed after public backlash, it's extremely concerning, and it's an extremely concerning example of where these laws could take us. And none of this is an exaggeration. 13 states have already passed trigger laws that would automatically ban abortion if Roe v. Wade is overturned. 9 states have abortion bans that are currently blocked by court order, but could take effect if Roe is overturned. Many of these states have very few or no exceptions for the safety of the woman, fetal death in the womb, or rape. Now, even though Nevada law protects the right to a legal abortion, these bans will also affect Nevada. It's already happening. Once Texas passed its 6-week abortion bounty ban, we started hearing reports from abortion providers here that people were traveling from other states so that they could receive legal, professional, and safe medical care. This is exactly why I joined amicus briefs in cases where abortion rights are at risk in other states, because banning safe and legal abortions in other states will inevitably affect Nevada's healthcare system. What we will not do is punish people for coming to Nevada to seek medical care. We will not work against people in the midst of one of the most vulnerable times in their life. Another concern that I have is that we don't know what the draft decision means for other constitutional rights that rely upon the constitutional right to privacy, bodily autonomy, and personal liberty that has been so critical to prior decisions on this issue. The draft opinion states that it's limited to abortion, but it heavily emphasizes that Roe could be overturned because abortion is not explicitly addressed in the Constitution. Many of our most basic constitutional rights are not explicitly mentioned in the Constitution. They're rather implicit and a part of the bundle of rights protected by the Constitution's guarantees of privacy, personal liberty, equal protection, and due process. For example, we don't know how this decision could be used in future cases that address the right to access birth control. The case that allowed unmarried women the right to access birth control was decided just 1 year before Roe v. Wade and relied upon similar understandings of the constitutional rights. We don't know how this decision could affect legal access to reproductive technology, such as IVFs. We don't know how this decision could affect the right to same-sex marriage or even interracial marriage. So many SCOTUS decisions, such as Texas v. Lawrence, Overturning versus Hodges, Griswold v. Connecticut, and Loving v. Virginia. All of these cases rely upon the constitutional right to substantive due process, the constitutional right to be free from government's undue restrictions on how adults can live their private lives and determine the course of their own futures. That liberty, the power to make choices about your own family, is exactly what is at stake. I believe that's why Nevada voters in almost every county approved the 1990 referendum that guarantees abortion rights here in Nevada. Without Roe v. Wade's protections against undue burdens on the right to an abortion, Nevada's law could be at risk for new laws that make it difficult for women to exercise their rights. We must also work to expand access to healthcare services. You can't exercise your right to see a doctor if there's no doctor for you to see, or if you can't afford to get healthcare. And this isn't limited to abortion services. As a state, we have much work to do to improve access to contraception and prenatal care, as well as address maternal mortality and domestic violence, which is a leading cause of death for pregnant women. My office will continue to play our part, fighting back attacks on abortion rights, rights to birth control access, and rights for LGBTQ people. All of these core constitutional rights that have been targeted by the same forces advocating for the end of Roe v. Wade and the constitutional right to bodily autonomy. For example, my office led an amicus brief effort against the Trump administration's Title IX rule, which resulted in a massive decline of family planning services, prenatal care, and preventive health services for low-income women. My office also joined in the fight against the Trump administration's attempt to allow health insurance companies to deny coverage for birth control. And my office will continue these fights. As your Attorney General, I will continue to use the weight of this office to defend your constitutional rights and our state law that guarantees your freedom. Thank you so much. I'll take a few questions.